He's an attorney, but is he representing somebody or is he acting on his own behalf? Because if he's acting on his own behalf, he has to be sworn.
I'm acting on your behalf, sir.
I'm representing Mr. Block
Okay.
as General Counsel for the State Republican Party.
Are you authorized by the party to represent Mr. Block in this matter? I understand the chairman is here. I'd like to hear from him as to whether or not you're acting on his behalf.
I'm sorry, what's the question? I apologize.
Is Mr. Pagliarini acting on behalf of the state party?
He has the authority to act on behalf of the state party, absolutely. He's general counsel.
Was there any authorization to act in this specific matter with respect to Mr. Block?
I don't believe it's required. As General Counsel, I can do that.
Well, that wasn't
myself.
my practice when I was counsel for the party, but there you go.
There you go. All right. I'd like to just make a clarification of whether or not you're subject to the APA. Under HAVA, in all matters related to HAVA, you are subject to the APA. So it's not voluntary, it's mandatory. There is a specific carve-out in the state law that says that if it's a HAVA matter, you are subject to the APA and all the rule promulgation and everything that's involved with that. So there was an incorrect statement that was made, so just for clarification purposes. Mr. Block is a layperson. However, he is a very well-informed layperson. He came to me with his complaint. I read his complaint. We worked on his complaint. And we made the decision that it needed to be filed with the Department of Justice. My decision was legally based. If you look at the same fact pattern that occurred in New Jersey in 2006, it went through the Department of Justice. Okay? And there's reasons why that occurred that I won't get into. However, I want to address the question that Mr. Block need not have answered under the line of questioning from Mr. Erickson.
Judge.
Commissioner Erickson, can we go with that?
No, Judge.
Okay.
You're an attorney, and my title for attorneys is judge. It always has been, and it always will be.
Very good, sir. So, the question was, would you be satisfied with the board's handling of it? I'm going to answer yes initially. If you read the New Jersey case, they were also required to backfill all the missing information.
Do you have the site for that case?
I believe it was provided.
I don't.
We have the site.
I don't have it with me.
I'm aware of the case, yeah.
Okay, so there's 143,000 alleged records that are missing the required information of either a driver's license or a social security number. The state of New Jersey had hundreds of thousands of records, and they were required by the Department of Justice to backfill that information. So, yes, we're satisfied at this point that you are working towards a resolution. Hopefully, next month we'll see that there is a recommendation before you, but that's part of the issue. The other issue is how are we going to get this missing information? Because each candidate who runs for office is disadvantaged when that information is not put there. This has nothing to do with trying to suppress anybody's right to vote. This is everything to do with protecting those people who voted so that their vote is not diluted by votes that should not have been cast, if they should not have been cast. We want the board to comply with HAVA. We like the board to please respectfully have all the information that's required. We have just begun to look under the hood. And there are several inconsistencies between rules that the board has promulgated in state law. There are differences within the law that are self-conflicting. There's a definition in one section, but there's a definition in another section that's in conflict with it. We don't want to prosecute these in the newspaper. We don't want to prosecute these in a court of law. We want to work with you from this point forward. So we would be happy to sit down with the board, with your staff, with Mr. McCarchio, and lay out exactly what we think some of the problems are. Because, quite frankly, there are problems in the electoral process here in the state of Rhode Island. Thank you.
Chair, I have a question.
All right, Your Honor, go ahead.
You know, it's a little think it's a little disingenuous to say, look, we've whacked you 5 times in the newspaper without telling you about it, and then say we want to work with you. Mr. Block, I don't believe has ever been before the Board of Elections before. Mr. Marion?
Many times.
Well, not when we were, for example, doing, I've never seen them, I've been here 3 years. And Mr. Marion comes, we work with them, we work with the ACLU, sometimes they attack us, sometimes they agree with us. Mr. Marion came up, gave us some good advice tonight. And yeah, there are problems, and we are addressing them. But fighting this in the news, to say now we're not going to whack you in the newspaper anymore, we're actually going to work with you, seems pretty disingenuous, don't you think?
I don't think so at all, sir.
Really?
Yeah.
Okay.
The other
Entitled
one,
to your opinion.
well, I am entitled to my opinion, but you've publicly been calling for that, and we're sitting here saying that we will work with you.
So now you agree with me,
I don't necessarily agree with your methodology, sir.
whatever works.
Now, and I'd like to parse a little bit of your argument about whether or not you have the right on public policy.
Are you familiar with the case?
I do not disagree. I have the floor right now, please, sir.
No, excuse me, I'm asking you a question. Are you familiar with the Republican Party of Minnesota v. White, the U.S. Supreme Court decision under the Roberts Court that dealt specifically with candidates for judicial and quasi-judicial authorities and the right that they have under the First Amendment to discuss matters of policy, not case law? If you're not familiar with that case, I'm really not interested in debating with you.
I am familiar with the holding. I'm not familiar with all the details of the case. However, I will make the argument that notwithstanding that you sit here as an adjudicator under certain cases that are brought before you. Some
Absolutely.
Cases you act as an administrator
Yep.
of the rules and regulations.
Agreed.
You're free to say what you want. Some cases you act as a legislator, you promulgate rules. You're free to speak whatever you want.
Yeah,
But when you act in a judicial manner,
but we're not here. This is regulatory.
I understand what we're here for.
Okay.
I'm telling you that you don't have a blanket exemption because Mr. Block has due process rights and bias can undermine those.
I
And
haven't-
your public statements have shown a bias. When you call Mr. Block a not credible witness,
Well, he isn't. He isn't an expert
That-
witness on election law under the Daubert standard. You know that.
I believe that you have no right to say that publicly, sir.
Oh, absolutely. I
And I'll
do.
leave it at that. Thank you.
Don't infringe on my First Amendment rights, Mr. Pagliarini.
Don't infringe on Mr. Block's.
I do not. He is free to say whatever he wishes to say.
Thank you.